I didn't get you there.
So when you received what I will refer to as Attorney Carney's file, and I will be mindful of using Attorney Zagangori's name, but if I fail to do so, it's not on purpose. So when you received the file from Attorney Zagangori and Attorney Carney, how did that physically come to you? Was it in paper form? Was it in electronic form?
It was in electronic form. Originally, what had happened was we sent the release. We didn't receive anything. Some period of time had gone by. We hadn't received anything. I called the office and spoke with either Attorney Zagangori or Attorney Fullerton and inquired about the file. They said it had been mailed, but I didn't have it. So they then duplicated what they said they would do it again. And said, they said, I think they told me at that point, you should have received a thumb drive with our file on it, but we had not. We asked for it again. They said they reproduced it. Then it happened that the same day in the mail, we got what they had originally sent, which was one thumb drive, and what they reproduced and sent the second time, which were 2 thumb drives. So I think now when we compared the two, they were not the same. So I don't know. The 1 thumb drive that was sent separately and the 2 thumb drives that were sent at another time were not the same, if you know what I'm saying. But ultimately, I think when you compare those 3 thumb drives together, I think we did get the full file.
So to be clear, because I think I'm confused, Attorney Carney sent you 1 thumb drive, which you did not receive. And then
initially did not receive,
did
yes.
not receive. And when you notified him that you had not received that, he sent what purported to be the same contents on an additional 2 thumb drives?
Correct.
And
Or, you know, I mean, just to be totally accurate, it may have been the other way around. The 2 may have been the first one to be sent, and the 1 may have been the second one to be sent. I can't, as I'm sitting here today, recall which was sent first and which was called second. But what we received was in one packet, 1 thumb drive, and in another packet, 2 thumb drives.
And if I'm understanding correctly, he purported those to be, the contents of those 2 packages to be the same.
Correct.
But they were not.
Correct.
At this point, do you believe you have access to their full defense file?
I believe so.
Okay.
Except for they never had produced that that child advocacy recording of Ms. Prout because they felt that they were not able to do that. So I did not get that from them. And then we never got trial notes, and we never got billing records. But I think everything else we did receive ultimately.
Generally speaking, I guess back up for a second, have you had the opportunity at this point to fully review that file?
Yes.
And generally speaking, can you give me the categories of information that were included?
Sure, there were, I mean, what you would typically see, there's pleadings, there's draft pleadings, there's discovery, there are sub-files for legal research. So if they were researching a topic, it was saved under a legal research folder, and then a subfolder of what the topic of legal research was, and then any cases they had reviewed, assumingly they reviewed, were under there. There were memos, there were notes, there were copies of some handwritten notes that I had given them. There was some correspondence. I think that's about it.
Was there what appeared to be trial preparation work?
Yes, there were subfolders labeled by people's names who I had identified as potential witnesses in the case. So there were subfiles for, the St. Paul boys, the police officers involved, the medical people involved, et cetera, with their names on it. And then in those subfiles, there were documents like, you would expect for, Detective Curtin, because I see her in the courtroom, so I'm thinking her, there would be a subfile for her, and her police report would be in there, that kind of thing.
Was there evidence in the file to suggest that Attorney Carney, Attorney Zagangori, and Attorney Fullerton had contributed to that file?
To some extent, yeah.
And what evidence did you see of that?
So if they were working on, say, a draft pleading, their mechanism for saving the pleading, which you could see, it was stamped on the pleading, so they would note it. So if it was created by Attorney Fullerton, she wrote it in the first instance, it would say a date created by, or draft, and then her initials, And then if somebody else contributed to it, the date would change and additional initials would be added. So if I saw a draft motion in limine pleading, it would say on the top corner, it was stamped with a date and then DF. And then I might see a later iteration of that same motion saved in that same subfile that has a different date, DF, SZ, or sometimes JW. JWC, I think, is how he did his initials.
Do you recall the date of Owen's final pretrial conference or trial management conference, whichever they refer to here in Maryland?
I don't remember the exact date. July 31st, maybe? I don't remember the exact date of it.
Were you present for that hearing?
Yes.
And that was the day that Attorney Carney filed a motion to excuse you from trial?
Correct.
Were you aware that was going to happen?
No.
Had he told you he was filing that pleading?
No.
Had he discussed it with you?
No.
Had anyone discussed it with you?
Nope.
Had you been in conversation with him in the days leading up to that hearing?
I can't remember the last time that we spoke, honestly, prior to that hearing. There was some correspondence back and forth, not a lot, but I recall my last correspondence with Attorney Carney was when he told me that he was going to have Attorney Zagangori co-counsel the case with him in July. And then after that, my correspondence had been with Attorney Zagangori to arrange for his affidavit and the filing of the motion for pro hoc vici for him. And then I don't recall additional conversations between myself and Attorney Carney since then, between that and the final pretrial.
How and when did you become aware of this pleading?
It was either handed to me as we were walking into a Chambers conference for the final pretrial or actually in the Chambers conference with Your Honor, and I can't remember which. It was moments before the Chambers conference, if not at the Chambers conference.
Had this ever happened to you before in a case where you had served as local counsel?
Never.
I'm going to object at this point. There's no ineffective assistance of counsel claim based on the allocation of the duties of the counsel. It's not an issue before the court. And I've allowed ample testimony in regard to their understanding or their lack of understanding about how their duties would be divided, but it's not a basis of the claim. And I think that this is prolonged testimony at this point.
Judge, the court has ruled that Attorney Rancourt is trial counsel. That was part of the basis of her recusal from this case. The state cannot just decide to disregard her involvement in this case and rely on Attorney Carney and Zagangori's affidavits. Attorney Rancourt's information, her knowledge, and her participation leading up to trial is relevant, and it's important to establish that basis because Attorney Carney then relied on her for significant and substantial pieces of trial, and her absence of information goes directly to her ability to contribute to those, specifically to the jury instructions.
No, I'll overrule the objection.
Thank you, Judge.
I'm sorry, can you repeat that? I don't.
Sure. So you became aware of his motion to excuse you during the Chambers conference?
Just before or in, correct.
And after Attorney Carney had excused you, did you have any conversations with him about specifically what role you would serve during trial?
So that day, the day he had excused me, we had a brief conversation in the hallway before the final pretrial and with Your Honor on the record about my concerns about not being here and what role I could provide if I was not present at trial. He asked me not to bring my concerns to the court's attention. I did somewhat on the record, probably not as articulately as I had hoped to, at the final pretrial. And then after that day, I consulted with ethics counsel of the Bar Association. Specifically, I had a conversation with Mitch Utel, who is, I think, the chair of the New Hampshire Bar Association Ethics Council, about my ability to serve as local counsel and not be present and what that would mean for me under the rules. And then following that conversation with Attorney Utel, I met with my partners to discuss our liability under those circumstances and wrote a letter to Owen outlining what my limitations would be if I were excused from trial and not present. And I copied that letter to Attorney Carney.
May I approach?
Yes.
Attorney Rancourt, I'm going to show you a document. Can you tell me if you recognize that document?
Oops, sorry. Yes, this was the letter that I drafted to Owen and copied to Attorney Carney regarding my limited abilities to assist. Okay.
Do you have, are you able to tell me what the date is on that letter?
August 4th, 2015.
And what was that letter drafted for? What was its purpose?
The purpose of this letter was really upon the advice of Ethics Counsel and upon the advice of my partners to create a record of what my limited role would be, because the New Hampshire rule for local counsel basically holds local counsel, my understanding of it was, it holds local counsel responsible for the actions of outside counsel even at trial. And if I was not there and didn't know what they were doing, I was concerned about being held responsible for what was happening in a courtroom when I didn't know what was happening. And so I wrote this letter to say, basically, my understanding is that I'm excused from attending jury selections, motions, and limine and trial. And in that role, my role will be very limited. I can't advise, I can't provide you assistance on local rules, I can't provide you assistance on interpretation of New Hampshire law. And I wanted to make sure that Owen understood that he would not have someone in the courtroom with knowledge of New Hampshire law and rules, and that he was okay with that.
Judge, I would ask that this be marked as Exhibit 1 for the defense.
No objection.
Granted.
Thank you. Did you ask Owen to take any action with regard to that letter?
I did. At the end of the letter, I specifically had asked Owen to check a box. I mean, I was shooting from the hip here. This had never happened to me before, so it was, trying to figure out how to proceed in this matter. I had asked Owen to check a box whether or not he wished me to appear as local counsel or did not wish for me to appear as local counsel, and to sign it.
And did he sign it?
I don't recall getting this back signed from him, but he did acknowledge to me in writing that he had seen the letter, discussed it with Attorney Carney, that Attorney Carney had advised him that this was the best, and that that he was going to follow the advice of Attorney Carney, and understood the contents of the letter, and that upon the advice of Attorney Carney, he was agreeing to waive my presence at trial.
Is it fair to say that at that point you understood you would have no role during trial?
That was my understanding. At that point, I understood that they had asked me to attend the mock trial session that they had previously planned with Owen, and then they had said, on the record and to me privately, that they would call me if they had questions as trial proceeded.
Were you in the courthouse on a regular basis during trial?
I came as a witness, not as a witness, as an observer, to observe on my own. Probably, I think my billing record showed it was about half of the trial. I just want to clarify. So if I was coming just to observe, I put it in my bill, but I didn't charge for it, obviously, because I was just coming to observe. So my billing records reflected what days I was actually present in the courthouse, because I need to account for my time with my firm. And then if they asked me a question or something during trial that they asked me to do, and I billed for it, I would bill for that. So my billing records, but through my billing records, I was able to recreate what I did as far as legal work and what I did that was just on my own, just coming to observe.
At some point, did Attorney Carney ask you to be more involved?
No, one,
That was a bad question. I'll withdraw that question. Did Attorney Carney or Attorney Zagagori contact you after the pre-trial when you had been excused prior to trial?
so, as I said, Attorney Fullerton contacted me about attending the mock trial in somewhere in Massachusetts, I can't remember where it was, and I did that. And then Attorney Carney and I spoke about jury voir dire and the process of jury voir dire and how that occurred. The 13th or 14th of August, and there was some email communication with Attorney Carney and I after that.
May I approach, Judge?
Yes.
Attorney Rancourt, I'm showing you another document. Can you take a second and let me know when you're prepared to speak about it?
Okay.
Can you tell me what that is?
This is an email between me and Danya, Attorney Fullerton, copied to Attorney Zagagori and Attorney Carney in July, which I remember this now. Attorney Fullerton had reached out to me and asked me if I would meet with Attorney Carney to discuss New Hampshire practice tips or something like that. And then I had responded and mentioned to them that Jaye would want to be prepared to speak with the judge about voir dire and how that was going to occur.
At that point, did he ask you any questions about voir dire or jury selection?
No. On July 29th, no. That was the first conversation I think we ever had about that.
Judge, may I return to the witness?
Yes.
Number 14. As with the last, just take a look at that and let me know when you're ready. Please.
So this, yes, I am, I guess is the answer to your question.
Can you tell me what the date is on that document?
August 14th.
And what is this document?
This was, as I recall, Attorney Carney and I had spoken via telephone on either earlier on the 14th or the 13th about jury voir dire and how that would occur. He asked me for materials that I may have regarding how panel voir dire would occur. I looked. I couldn't find what I had originally thought I could find. So then I forwarded him something I had found from the National Association of Criminal Defense Lawyers resource manual on voir dire, and I had copied a portion of that manual and forwarded it to him with this email on the 14th.
Judge, I would ask that those documents be marked as Exhibits 2 and Exhibits 3. I think if I have the numbers correct.
I thought you were going by the number.
I can. Is that easier for you? Sure, I can do that. That would be Exhibit 20 and Exhibit 14 then.
I have no objection. I just want to make sure that we're all clear. So are we going to go back and mark item number 1 as item number 27?
I think the clerk was doing that anyway.
So we have, our first exhibit is number 27, our second exhibit is number 20, and our third exhibit is number 14. Is that correct?
That's my
Is
understanding.
it, just so I'm clear, Ms. Malone, you had pre-marked your exhibits with a monitor
I provided the monitor with a list of documents that I intended to use,
with exhibit numbers on it?
with exhibit numbers.
Why don't, during the break, let's have them all pre-marked, at least for identification.
Sure.
And then with whatever numbers they need to be marked as, and then you can, if they're agreed to, you can mark them as full exhibits. But if they're not, you can mark them for identification, and as and when you want them admitted, you can seek to strike the identification. For the record, the identification on the 3 exhibits that you have referenced are struck, and they will be admitted as full exhibits without objection.
Thank you, Judge.
So, and I just want to be clear, they've been marked for ID based on the list provided by Attorney Malone.
I don't think they've been marked for ID yet, but over the break, they will be.
Okay. I guess it would be my preference.
They already have been marked.
Okay, the monitor is informing me that they've already been marked for identification.
That was my understanding. If we
Okay.
strike the ID, could we identify the full exhibits in order as 1, 2, 3, 4, 5, just so that it's clear how they're coming in? I think that we're opening ourselves to a lot of confusion if we
Well,
jump in order.
why don't, they aren't 1, 2, 3, 4, 5, they're the numbers that you indicated, which are, there are 3 exhibits.
1 through 29.
But if we strike the ID, we can't give them a new full exhibit number? We can't do that?
They've already been marked for identification, so we're striking the ID on exhibits that have already been marked for identification.
And they, okay.
So the numbers will stay the same.
Okay. Thank you.
Yeah.
So Attorney Rancourt, at the time that you communicated these 2 emails with Attorney Carney, which was August 14, and I believe the other one was August 17, is that correct?
One was July 29th. My response was July 29th, and one of them, the second one, was sent by me to Attorney Carney on August 14th, 2015.
Up to jury selection, was that your extent of involvement in preparing for jury selection?
Other than I did have some email correspondence with Attorney Fullerton just about the mechanics of getting the questionnaires, contacting the court and ordering the questionnaires and paying the fee, etc.
Were you involved in preparing any voir dire questions?
No.
Did you discuss with Attorney Carney and Attorney Zagangori the form instructions?
No.
Did you discuss with them any instructions that you would typically use in a sexual assault case in New Hampshire?
We're talking about instructions or selection?
I'm sorry, selection. Any voir dire questions that you would use? Thank you. Any voir dire questions that you would typically use in a sexual assault case in New Hampshire?
No, I wasn't asked any questions about that. Other than providing this email with the research materials from the National Association of Criminal Defense Lawyers, I did not forward them anything else.
I understand that you were present for jury selection in this case.
I was.
How did that come about?
I received a call the night before jury selection from Attorney Carney asking me to be present for jury selection.
Did he tell you what he intended for you to do if you were present at jury selection the following morning?
No, I recall, well, I guess a little bit is more accurate to say. I recall the conversation being that he had called me on my cell phone, that would have been a Sunday night, and said, I've decided that it might be helpful to have you there for jury selection for procedure and whatnot to advise me if I have questions.
For procedure and to advise him if he had questions?
Correct.
And to be clear, that's a summary of your recollection.
That's my recollection. I don't have anything in writing, that's just my recollection of what he said to me.
So before you appeared for jury selection, had you reviewed the juror questionnaires?
I never saw them. I did not receive them, and they did not forward them to me.
Typically, when you do a jury trial, how would you prepare for jury selection?
My typical process would be I order the questionnaires, then I read through the questionnaires. I prepare some kind of spreadsheet with relevant information about the jurors that I can easily refer to, rather than referring to the questionnaires themselves. I refer to my spreadsheet with their name, occupation, where they're from, any information that might strike me good or bad, that I see in the questionnaires. And then so that I can use that spreadsheet in the selection process.
Were you provided with anything when you appeared for jury selection?
No, but prior to, no, I appeared in court that morning. I had not seen anything from the jurors as far as questionnaires or a spreadsheet or anything of that nature.
Did Attorney Carney or Attorney Zagangori or anybody give you anything that morning for jury selection?
That morning, either one, I don't remember which one, whether it was Attorney Zagangori or Attorney Carney, handed me a stack of questionnaires and said, can you locate the questionnaires as they're called, as the jurors are called, as their numbers are chosen?
Were the questionnaires organized in any fashion?
They were, I believe they were in alphabetical order, like they come from the court.
Did it appear that they had been at all processed or prepared in any fashion by Attorney Carney or his office?
When I received the stack, they were as if I had received them from the court. They were not marked up, they were not highlighted, they were just the questionnaires.
Did you receive any additional information or guidance going into jury selection about what you should or should not be looking for or things of that nature?
We've never had it. I don't know whether they had conversations about that. They had not had any conversations with me about that.
So what did you do during jury selection?
I stood over there and by the where the forms are about, and as the jurors were called, thumbed through the questionnaires, pulled them out, and read them as they were either walking to the bench or sitting in the box.
Is it fair to say that's not typically how you would manage jury selection?
That's fair.
Did any issues arise during jury selection?
Well, at one point I recall that a juror was selected whose employment at a law firm associated with the case. I picked her, she was called, I picked up the questionnaire, I was reading it, she was going to sit in the box, and I flagged it, I think at the same time that Attorney Ruffle had noticed that there was also a problem with that. And I had kind of grabbed Attorney Carney and said, no, wait, there's a problem, we got to talk about it. But Attorney Ruffle had already, I think at that point, said, to Your Honor, we would need to speak with this juror.
Were you prepared to handle jury selection?
No.
Were you present when Andrew Thompson testified during trial?
No, I was not.
And I think we've established through earlier questioning that you were not present for the Chambers Conference called to address the issue of the line of questioning that Attorney Carney had pursued.
No.
Had you at all been made aware of that line of questioning or the issue that arose during trial?
I can't recall if it was during trial or immediately after trial. I believe that someone in Owen's family had talked to me about it and expressed to me some kind of concern about it. But I can't remember whether that was during or after.
Fair to say that neither Attorney Zagangori nor Attorney Carney contacted you about that issue during trial?
That's fair. They did not.
You drafted the notice of appeal for the New Hampshire Supreme Court?
I did.
Are you still counsel on that appeal?
I am.
How did you inform yourself to prepare the NOA since you were not at trial?
We listened to the transcript of the trial because I had not been present for the whole trial, so in order to flag any issues that we thought were relevant for the notice of appeal, myself and an associate in my office ordered the recordings and listened to the recordings because you only have 30 days to file a notice of appeal, so you can't really get the transcripts in time. So we listened to it.
At that point, did you have Attorney Carney's file?
I don't recall if it arrived in time within the 30-day period of time.
One issue you raised in the appeal, and which has been raised in the motion for new trial, is whether the court erred in precluding the defendant from cross-examining a key prosecution witness with evidence tending to impeach the witness's credibility. Is that accurate?
That's correct.
And that witness was Andrew Thompson.
Correct.
So I think we've established again that you were unaware of all the information that pertained to that witness's testimony.
You know, as you say that, I think we did have Attorney Carney's file because we had looked at Mr. Thompson's email account, which had been included in discovery by the time we filed the notice of appeal. So we must have received Attorney Carney's file because we did not, if I recall correctly, the discovery that we had received, that my office had received, I don't think we had the same access to all the full email accounts of certain St. Paul students. But I think we had that full access once we got Attorney Carney's file, so we probably had seen that file by the time we filed the notice of appeal, because I recall that we had looked at Andrew Thompson's inbox, outbox, and deleted emails by that point.
I want to come back to the point. I want to back up for one practical point. Did you file a motion for a new trial? You drafted the original motion for new trial that was filed with this court. Is that accurate?
Correct.
Did you draft that pleading at the same time that you were drafting the notice of appeal?
No, the notice of appeal was due 30 days after sentencing. We had flagged a couple issues, I think, within 30 days. I mean, we certainly were thinking, I think it's accurate to say, we were thinking there were problems and that may be something that we had to do, but we were not drafting it yet.
Okay, now I want to return to the issue of the email inboxes. If I'm stating correctly, you indicated that you had student email boxes?
So, in some form, and again, I can't recall whether the discovery that my office had been sent as local counsel had full access or not, or whether that came only when we got Attorney Carney's file. But at some point, we realized that in discovery materials, the full email accounts of some students had been provided. So it looked to us as if what had happened was the state had received from the St. Paul's school kind of a capture of their full email accounts. So we could see outgoing emails, incoming emails, deleted emails for some period of time for certain students, including, I can't remember all of them, Ms. Prout, Owen, Mr. Thompson, and a few others.
So in preparing to draft the notice of appeal, in addition to reviewing the transcripts, which you had at that point, you reviewed the discovery and these email boxes?
I'm sorry, for the notice of appeal, we did not yet have the transcript.
Okay.
So for the notice of appeal, we had started a review of discovery and had seen some of the emails. Whether or not we had done our full review of all the emails or not at that point, I don't recall, because we did ultimately need to download some software in order to fully access the email accounts.
So how did you become aware of the failure to cross Andrew Thompson as an issue?
Well, it was in the record. So when we listened to the tapes, that was on the tapes. I mean, Attorney Carney had begun to cross-examine Mr. Thompson on the issue of Ms. Wells, and there was an objection, and there was a bench conference, and that was on the bench conference may have actually been sealed and not on the original tapes, I can't recall, but there was obviously that line of inquiry that had begun and was stopped. So we knew that, and then we'd spoken with Owen about it, and then we looked at some of the materials that we found regarding that line of cross, where it was in the discovery, the paper discovery, and some of it was in Mr. Thompson's email account.
What materials did you find that were relevant to that line of questioning and that issue for the notice of appeal?
So in the actual discovery, the printed discovery we had received, there was a Facebook exchange between Mr. Thompson and Ms. Wells that had been provided by the state in discovery, which I had probably had originally in my discovery. Some reference, obviously, to emails between Mr. Thompson and Ms. Wells that the police had discovered based upon a review of his email accounts. And then our review of Mr. Thompson's email account revealed the correspondence between him and Ms. Wells and him and Ms. Prout.
And did you consider those documents when you were preparing the notice of appeal and ultimately the motion for new trial?
Yes.
Judge, may I approach the witness?
Yes.
Judge, if I can have just 1 second.
Sure.
I can do that later if you want to mark it. Okay. Judge, I realize that there's some extra pages in one of the exhibits. I can pull those later if the court would like. I think I can proceed for purposes of testimony if the court wants to go. I mean, I think as long as they come out at some point, are you okay with that? Or do you want me to do it now before proceeding?
I just want to make sure that I have the same pages and exhibits that you have.
They're right here. Sure. So I pulled the pages that you indicated. So, and now what I'm left with is this. And then starting at page 289, which is just one of those. And then I have one. So you separated it. Oh, you do have the other one. I do have it. Okay. Okay. So then we don't need to strike it. Okay. Thank you. Well, thank you. I apologize, Judge. They did have it.
Okay.
I had nothing. May I approach the witness, Judge?
Yes.
Thank you. Attorney Rancourt, I'm showing you two documents. One has been marked as 10A, one has been marked as 10B. You could take a look at those, please, and let me know when you're ready to discuss.
Okay. I'm ready.
Do you recognize those documents?
I do.
And do you recognize them to be documents that were taken from Attorney Carney and Attorney Zagangori's file?
I do.
Can you tell me where you found those documents?
The 10B, which was the Facebook exchange between Andrew Thompson and Ms. Wells, that was in discovery materials. That's bait stamped with the other discovery materials from the state. The 10A is two separate emails that were in Mr. Thompson's email account. If I recall correctly, recovered from his deleted email accounts, if I recall correctly, but I wouldn't say that 100%.
And did you consider these emails and that Facebook exchange relevant when drafting the motion for new trial and the notice of appeal?
I did.
On the issue of failure to cross-examine or to failure to impeach Mr. Thompson's credibility?
I did.
Can we speak first to what I believe is marked as 10A, which is an email exchange between Mr. Thompson and Mr. Prout?
Yes.
Are you aware of whether or not that document was used or presented to the court during trial?
It was not. I am, and it was not.
How would that document have been used to cross and impeach Andrew Thompson?
This email is an email exchange where Ms. Prout is part of the exchange, and Mr. Thompson is part of the exchange, and 2 other St. Paul students are also part of the exchange. And looking back at the trial and Mr. Thompson's testimony, listening to it and then later reading it, Mr. Thompson had testified in trial that he didn't know Ms. Prout very well, that I believe he said she played volleyball or something, I might have the sport wrong, with my sister, and so someone knew her in passing but didn't really know her. That was one part that I thought it could be used for. And then the second part was that he claimed to say that he told Owen prior to him meeting Ms. Prout that he shouldn't do it. He shouldn't meet up with her because she was too young. And this email exchange is for him, Mr. Thompson, setting up to meet Ms. Prout.
How specifically would it have been used to impeach his statement that he did not know her well?
Well, first, like I said, he said he didn't know her well. He said he just knew her through his sister, basically. This email exchange, the subject of this email exchange, sorry, it's not the subject, it's mentioned in the body of the email exchange, is arranging what's called a secret snuggle with Ms. Prout and another freshman, I don't remember how they refer to themselves, but I'll call it a freshman, another freshman student and another, I think, senior boy.
Can you read the progression of the email for me, please? I'm sorry, if you could also indicate the speakers or the writers of the various portions of the email.
Okay, so the email, apparently, it first comes from Duncan Norton with copies to the others that say secret snuggle. There is a response from Ms. Prout that says, "Is it even a question?" Duncan Norton then replies, "Secret snuggle, time and place." Ms. Prout then responds, "Your call, boys." Mr. Thompson then replies, "My lap, tonight at 9 p.m.
Why would that have been relevant to impeach him?
Because this email would indicate a relationship more than just knowing someone through their sister. I think if you're inviting them to your lap at 9 o'clock, there's at least an implication of that.
I'm going to object to that response. That is purely speculative, Your Honor.
Well, the email speaks for itself.
But her conclusions, Your Honor, I would
I
object to.
understand.
I would draw your attention to the second portion of emails, which are part of 10A.
Yes,
Do you recognize those documents?
yes.
And just to state the obvious, I think this is a series of different emails. Is that an accurate representation?
Yes, that's accurate.
Have you had the opportunity to review this document? Are you familiar with it?
Yes, I've reviewed it before. I'm just kind of refreshing myself looking at it now. This is an email exchange between Ms. Wells and Mr. Thompson.
Ms. Wells and Mr. Thompson.
Ms. Wells and Mr. Thompson, yes.
And why did you think that this would be relevant to impeach Mr. Thompson?
Again, Mr. Thompson had testified at trial that he advised Mr. Labrie that he thought it was a bad idea for him to go and meet with Ms. Prout because of her age. And this email exchange between him and Ms. Wells, who was the same age as Ms. Prout, that as far as I understood, was basically arranging for him to sneak out and meet Ms. Wells after hours on the St. Paul's campus.
How would that be relevant to impeach him? On what point?
As I said, he said that he told Mr. Labrie it's a bad idea because of her age, and yet he's sneaking out of his dorm to meet an underage girl around the same time. I think it implies that there's a question whether or not he would really make that statement based upon his own actions.
I would turn to 10B. If you could do that for me, please.
Yes.
I believe you indicated that this is a Facebook exchange between Mr. Thompson and Ms. Wells.
Correct.
Are you aware of whether, I apologize, I'll step back. Are you aware of whether the emails that we just discussed were admitted during trial? I think I asked you about the first one, but the second set of emails, were those admitted at trial to your knowledge?
No, they were not.
Were they contained in Attorney Carney's file?
They would have been in the email accounts. I don't recall them being pulled out and in that sub-file of documents labeled like Mr. Thompson, like the Mr. Thompson's or Andrew Thompson's sub-file, which would have been like his witness file. I don't recall them being in that sub-file, but they were certainly in the file as far as in discovery materials.
So in speaking about the Facebook exchange, you determined that this was relevant on the issue on both the notice of appeal and the motion for new trial about impeachment of Andrew Thompson?
Impeachment of Andrew Thompson, as well as a selective prosecution argument.
Can you speak to the impeachment piece for me first, please? Why you believe this was relevant for impeachment purposes?
I determined that this would be relevant for impeachment for the same reason as the other exchange with Ms. Wells, because of Mr. Thompson's statement that he allegedly told Mr. Labrie not to meet with Ms. Prout because she was too young. This is a Facebook exchange between him and Ms. Wells, who was the same age, and what appears to be, from the face of it, from the words of it, arranging for him to meet her at summer camp, and then the discussion goes on about whether it would be illegal for them to get together.
In what context, based on your knowledge and experience, would a meetup between these two individuals have been illegal?
They specifically discussed their age difference and the amount of years between them, which would be, the way I read it, a reference to the sexual assault statute and whether or not it would be a violation for them to have sex.
Again, Your Honor, I'm going to object to the response. It is purely speculative and it's based on her conclusions that she's drawn.
I'm overruling it not because the question really has to do with how she would have assessed it in terms of potential cross-examination material. And in that context, her point of view, whether it's speculative or not, whether it has to do with the statute or not, is admissible. So the purpose is not really for her to be talking about what the actual motives of the underlying correspondence were, but how she would have assessed it in terms of cross-examination material.
I want to turn for one moment to the Chambers Conference, the confidential Chambers Conference that you ultimately came into possession of. Are you familiar with that Chambers Conference at this point?
Yes.
Are you able to speak about or answer questions about that Chambers Conference at this point?
Based upon what I've read only.
Are you aware of whether or not the court was made aware of this document during that Chambers Conference?
Based upon the reading of the Chambers Conference, it does not appear, well, I know it wasn't referenced as far as nobody referred to a Facebook exchange or brought Your Honor's attention to a Facebook exchange or an email exchange. And based upon a review of the Chambers Conference, it would not appear as if any documents were provided to Your Honor in the Chambers Conference.
How would provision of the document have been significant and relevant and important for purposes of that Chambers Conference?
Based upon my review of the Chambers Conference, it appeared as if there was some question about this, whether or not the area of cross or that line of cross would have been speculative or what it was based on. You know, what that knowledge of the relationship between Mr. Thompson and Ms. Wells and their possible sexual relationship, what that was based on, whether that was pure speculation, rumor around campus, what was, you know, where did that come from? That was some part of the discussion. And it would occur to me that if you provided Your Honor with the written documents of their back and forth between the two individuals saying, is it illegal? I don't know. Don't we have to be more than 4 years apart? No, I think we have to be 3 years apart. I don't know. We'll look it up. Would have implied that that was the nature of the relationship.
Are you familiar with, having reviewed the transcript, the purpose that Attorney Carney initiated that line of cross-examination with Mr. Thompson?
Oh, geez, I'm trying to remember. My recollection of it is, obviously the transcript speaks for itself, but my recollection of it is that Attorney Carney originally attempted to get into it, and when they approached the bench, he indicated to Your Honor it would go to his motive to fabricate, to protect himself. It would go to Mr. Thompson's motive to fabricate negative information about Owen in order to protect himself from prosecution because of his own relationship with Ms. Wells.
And you believe this Facebook post would have assisted in doing that?
Yes.
Did you undertake any steps to identify what a secret snuggle is?
I did.
And were you able to find out?
I was. I had, I believe through a friend, Owen had, maybe Owen or another one of the St. Paul students had directed me to a St. Paul student that we could speak to who could define these terms for us, including the term secret snuggle.
And what does secret snuggle mean?
And she had defined for us, and there was an affidavit I believe we attached to the motion for new trial. She had identified for us that a secret snuggle, that her interpretation of that around the St. Paul's campus was a sexual encounter of some kind, or an intimate encounter of some kind, I guess.
Why was impeachment of Andrew Thompson relevant and significant in this case?
Because Andrew Thompson, I think his testimony was somewhat critical. He was Owen's roommate and had previously been identified as one of his best friends, and yet took the witness stand and said that he told him not to go, that it was a bad idea, implying that Owen had certain intentions when he went to go meet with Ms. Prout, which was not told by, that testimony did not come in through anyone else other than Mr. Thompson. And then the state in their closing actually relied on the testimony of Mr. Thompson and said, this is his best friend, this is his roommate, this is the person you should rely on, this testimony is critical, and actually drew the jurors' attention to Mr. Thompson's testimony. So I think impeaching Mr. Thompson on that issue with his own actions and words would have been critical to the trial.
Critical in that it would have challenged his credibility?
Exactly.
Pre-trial, did Attorney Carney or Attorney Zagangori ask you for any information on the rules of evidence?
Occasionally. I mean, specific questions, occasionally, yes.
Fair to say that the rules of evidence in New Hampshire mirror the federal rules of evidence?
Yes.
Did you and Attorney Carney speak, or you and any of the other folks involved from Attorney Carney's office, speak specifically about 404B evidence?
No.
Are you aware of whether Attorney Carney's office had conducted any specific research on that issue pre-trial?
After the fact, by reviewing their file.
Did Attorney Carney or anybody from that office ask you specifically about New Hampshire law on prior sexual conduct?
No.
Are you aware of whether they had conducted any research on that issue pre-trial?
I can't recall if there was a sub-file for that research or not. There may have been, I don't recall.
Are you aware of any pre-trial orders on this point?
Yes.
Are you familiar with those at this point?
At this point, yes.
Are you comfortable to speak about those orders?
Yes.
Have you previously tried sexual assault cases?
Yes.
And you've previously had to deal in your professional career with 404B evidence?
Many times.
And evidence of prior sexual conduct?
Yes.
Being aware of the court's orders pre-trial on those issues, how could that exchange, that email exchange or that Facebook exchange with Andrew Thompson have opened the door to prior sexual contact between Owen and any other individual?
I don't think it would have. It would have been introduced to impeach Andrew Thompson. It wouldn't have been introduced for any other purpose. I don't think that opens the door to any conduct of Mr. Labrie.
Can you conceive of an argument or a manner with the pretrial orders in mind and how that would have been the case?
No, because Mr. Labrie's conduct is wholly separate from conduct of Mr. Thompson, and this was only relating to Mr. Thompson's conduct with another person.
And do you believe that presenting the, I'll call it the secret snuggle email, would that have violated the court's order on evidence of prior sexual contact or activity? And if you're not comfortable answering that question based on familiarity with the order, please just say so.
I don't think so, but I'd probably have to read the order again to make sure that.
Were you present when Chessie testified at trial?
Yes.
And have you had the opportunity to review the transcript of her trial testimony?
Yes.
Are you comfortable with her testimony?
Yes.
Have you reviewed the discovery as it pertains to Chessie?
Yes.
And having reviewed Attorney Carney and Attorney Zagangori's files for discovery, what information or what types of information did you find in their file about Chessie?
Again, we had numerous statements. I mean, the police had interviewed many students at St. Paul's, so we'd reviewed all those statements. Some were recorded, some were Skyped conversations, some were transcripts of conversations. We reviewed all those. We also reviewed Ms. Prout's, same thing, her email accounts, her incoming emails, outgoing emails, deleted emails.
In preparing the notice of appeal and the motion for new trial, what specific pieces of information relating to that file, from that file relating to Chessie specifically drew your attention?
There were a couple things that caught our attention. Relating to the issue of whether or not any of these emails would have violated the pretrial order, at some point, Your Honor had ruled during the testimony of Ms. Prout that the door had been opened to prior sexual experiences based upon her testimony. So she had testified about, I don't remember what she said, but she said something. There was a bench conference. I think Attorney Carney had moved to strike the testimony, then they had a bench conference, and then Your Honor's ruling ultimately was that the door had been opened. So this email between her and Andrew Thompson, at that point, I believe the door was opened to that email to the extent that the 10A email referenced any kind of intimate encounter. There was another email in her inbox, or maybe it was in her deleted mail, between her and another senior, where he had invited her to a senior salute the same evening that she had met with Mr. Labrie, and there was some indication that she may have accepted that. They were discussing meeting that day. Whether or not the meeting ever occurred, it was not clear from the email. So I think that the door was opened to some of those emails at that point in testimony. That drew our attention. And then there was an email containing a photo which had drawn our attention.
Can you tell me about the photo?
There was an email from Ms. Prout's mother to her which contained, it was an email from Susan Prout to Chessie Prout containing photos from that weekend where this encounter had occurred. And in that box, in that email, the attached photos we could see, and one of the photos was of Ms. Prout jumping on a trampoline and doing like a split in the air on a trampoline, which our attention was drawn to that photo because recalling her testimony that she had said she was so sore she couldn't walk downstairs, she couldn't sit on the floor, she was in so much pain that photo seemed contrary.
Judge, may I approach the witness?
Yes.
Thank you. Showing you two documents that have been marked for ID as 2 and 3. Can you take a look at those, please? Just let me know when you're ready to discuss.
Okay.
Can you tell me if that email, which is marked as 2, is the email that you were referring to?
Yes, it is.
And that email includes a number of photographs.
4.
Is the one of the image on the trampoline included in that email?
It is. It's in the page references, it's the last page of the exhibit.
Do you recall where that email was found?
In Jesse Prout's email account, whether it was in deleted email or received email, I can't remember. I think it was just in the received email, like inbox.
I would draw your attention to 3, which I believe is a screenshot of an electronic folder. You look up the upper right hand, it should say complainant. Is that the document that you have in front of you?
Yes.
Can you take a look at the second page of that document?
Yes.
Can you tell me where what this document reflects and what it is?
So as I said, when we reviewed Attorney Carney's file, there were sub-files created for potential witnesses. And so at some point, we had located a file that was called Complainant, was the name of the sub-file. And then if you click on that file, it brings up whatever was saved underneath Complainant. And then the first page of Exhibit 3 is a screenshot of the properties and what was saved there. And then the second page is that same file, the Complainant file, just with the images of what was saved there instead of just the list of what was saved there.
So the first page is the same as the second page, it's just reflected in a different manner. One is icons and one is a list, is that fair?
Correct, yes.
Was there another folder that you found anywhere in the file that you were provided by Attorney Carney's office labeled Chessie Prout, Francesca Prout, Complainant?
No, this was the only file we could find.
And I want to ask you if all the emails reflected in that email, all the photographs reflected in the email, are all of those photographs included in those that were downloaded in the complainant file?
No, when we compared the two of the photos, the first 2 pictures of Exhibit 2 were included in the complainant subfile, and the last 2, the trampoline pictures, for lack of a better term, were not included in the complainant subfile.
So the photos of her jumping on the trampoline were not included in the complainant file?
No.
They were only included in her email box?
Yes.
I apologize.
Yes, they were not, recreated, pulled out by Attorney Carney's office and put into some other file. They had not, the file did not reflect that that happened.
And are you aware of whether those photographs were used at trial?
They were not.
Are you aware or were you part of the discussion about whether or not to use those photographs?
No, I had no discussions with either Attorney Zagangori or Attorney Carney regarding their theories, their cross-examination of Ms. Prout, what they were going to use or not use. We never had those conversations.
And you believe that that photograph of jumping on the trampoline could have been used to impeach Ms. Prout?
Yes.
Can you articulate why, please?
Again, because she had testified about how sore she was after her encounter with Mr. Labrie. She had said to some fairly graphic explanations of it hurt to walk downstairs, it hurt to sit down, it hurt to take a shower, etc., indicating she was in some substantial pain. And this email picture would have indicated that the next day, I believe, or when the pictures were taken, maybe it was 2 days later, that she was jumping on a trampoline and doing splits, which I think, certainly would have implied that statement is not accurate.
Are you aware of Ms. Proud's testimony about her receipt of and response to senior salute emails from other individuals?
Yes, I recall the testimony from Ms. Proud on that topic being that she had received other senior salutes and had either not responded to them or said no, had declined them.
Sorry, Judge, I would step back for one moment. I would ask that those last 2 documents be marked as full exhibits in the ID stricken. That would be 2 and 3.
I'm sorry. No objection.
Granted.
Handling the list.
Thank you. Did you find emails in Ms. Proud's email from other individuals sending her senior salutes?
Yes,
And did you find that she responded to those?
yes.
May I approach the witness, Judge?
Yes.
May I approach, Judge?
Yes.
1D. Thank you.
Attorney Rancourt, I'm showing you 2 documents that have been marked as 1D and 1H for identification. Take a look at those, please.
Okay.
Do you know what those are?
These were emails from Ms. Proud's email account.
And they were found in her email account that you had access to through the discovery?
Yes.
Were they in the complainant folder?
No.
And what do they represent?
1D are email exchanges between Ms. Prout and Duncan Norton. And then the last page is an email between Ms. Prout and a St. Paul student named David Na.
And why would those be relevant?
Well, the Duncan Norton email would have been relevant because there was a question. My understanding of her testimony was that she said she had received other senior salutes and she'd either said no or not responded. And the Duncan Norton email we felt was relevant for 2 reasons. One, because it is not a rejection. It appears not to be a rejection. I mean, like I say, I don't know what ultimately happened, but from the email exchange it says, running out of sunsets, 2 true from Ms. Prout. I might be able to make room for you tonight, which was from Duncan Norton to Ms. Prout. And of relevance to us, of course, and that email also was that I believe that was the same night that she had arranged to meet with Mr. Labrie.
Judge, I would ask that the ID be stricken and they be marked as full exhibits.
No objection.
Why did you think that the email specifically with Duncan Norton had significant relevance?
Because there was an implication that it was contrary to her testimony. I mean, her testimony was, I either said no or I didn't reply, but she didn't say no, and she did reply to Duncan Norton. And the judge ruled she had opened the door to exploration of other intimate contact. And there was a question whether or not she and Duncan Norton, whether or not they did meet up on that evening, and certainly follow-up questions regarding that area of inquiry would have been relevant.
Was there other evidence to suggest that she had met up with Duncan Norton that night?
Other than the email exchanges, I don't believe so.
Are you familiar with the DNA evidence?
Oh, yes.
And what of the DNA evidence could suggest, I'm not asking if it concluded, but could suggest that she had met up with another individual?
My recollection of the DNA evidence was that the DNA had found that in one of the DNA samples recovered from the underpants that there had been 2 or more contributors to the sample.
The state has argued in their objection that various areas of cross were not pursued because those lines of cross would have opened the door to prior consistent statements by Ms. Prout. Did you consider that in raising the motion for new trial?
I did.
And what did you ultimately decide, and how did you decide that it was still an issue valuable, important, and significant?
Well, I read McSheehan, probably is the case that, I don't know if that's the most recent case from the New Hampshire Supreme Court or not on it, but it's certainly on point, which basically is a direction from the New Hampshire Supreme Court limiting prior consistent statements and how those can come in, and that the statement has to be consistent with trial testimony, not consistent with other statements that may have been made before and should be used in very limiting circumstances. And so looking at this discrete area or these 2 discrete areas referring to the photo and the emails, I don't see how that would have opened the door to prior consistent statements. It would have been impeaching Ms. Prout on specific statements, whether or not she had been injured, as she had testified. And then the other statement was regarding her accepting of previous emails, previous senior salutes or secret snuggles, those types of things, and what appeared to be 2 acceptances, or 2 a possible acceptance with Duncan Norton, I guess I should say, would be more accurate, and what appeared to be an acceptance to Mr. Thompson.
So again, you're familiar with the court's ruling on prior sexual conduct. In its opening, the state indicated, and I believe stated outright, that Ms. Prout had no prior experience. And I'm paraphrasing, no prior sexual experience was the inference. Would these emails have contributed to counter that claim as well?
I believe so.
And how would that have been valuable for Owen?
It would have been valuable to Owen because ultimately Owen's case, I think when you boil it down to its essentials, was a he said, she said. Nobody else was there. And so the jury is left with determining who they believe. And if you can impeach the testimony of a complaining witness to say what you just said isn't true based upon this documentation that I'm confronting you with, if you can close the loop on that or come pretty close to it, it's valuable.
Are you familiar at this point with documents contained in discovery? And I'm speaking only to documents contained in discovery for this case, for the criminal case. Are you familiar with documents contained in discovery relating to Dr. Gettens?
Yes.
And can you articulate for the court who Dr. Gettens was?
My understanding was that Dr. Gettens was like the dorm monitor, dorm parents for the dorm in which Miss Prout lived. I think that's accurate title.
Would you like water?
That'd be great, thanks.
And Krishna.
Yes.
Are you aware of whether Dr. Gettins gave a statement to the Concord Police Department when they were investigating this matter?
She did.
Are you aware of what that statement was?
My understanding was that she was questioned by the Concord Police Department regarding her recollection of her contact with Ms. Prout the evening that she was crying and upset in the dorm, which would have been that same evening that I believe she had contacted her mother, that Tessie Prout contacted her mother, Mrs. Prout, and reported that she had been assaulted.
Are you aware of whether Attorney Carney or anybody working for him made attempts to contact Dr. Gettins?
Based on my review of the file and my later conversations with the investigator in the case, I am.
And did anybody attempt to contact her?
No.
I guess as a side note, did Attorney Carney have attempt to contact anybody from St. Paul's School?
Some previous students, I believe, had been contacted by the investigator. Possible current students, I don't remember, maybe through their parents, had been reached out, the investigator had reached out to. My understanding was that no teachers or employees have been contacted, and that was, my knowledge from that came from my conversations with Attorney Delaney, because Attorney Delaney, who represents, maybe I think currently still does, the St. Paul's School, contacted me and said, I'd be happy to make arrangements. He contacted me and said, I'm happy to make arrangements for you to interview any employees or any current students who are still on campus if you would just go through us so that we can, make the proper arrangements. We'd be happy to do so. I had passed that information along. And I think Attorney Delaney actually reached out to me again after the fact and said, didn't hear back, you guys want to interview anybody? And what I received back from Attorney Carney's office was, we'll reach out to him if we want to, if we need to, I think, is what they had said to me.
You're aware of the state's argument that prior consistent statements could have been damaging to Mr. Labrie's case?
Ms. Prout's prior statements?
Yes, I'm sorry. Ms. Prout's prior consistent statements.
I read that in there. I have read their objection to the motion for new trial, so I read that in the objection.
Do you believe that Ms. Prout had made prior consistent statements that could be harmful to Mr. Labrie?
No.
Why not?
I don't think the statements were consistent. Number one, I don't think that the areas of cross-examination that we raised in the motion for new trial would open the door for those prior consistent statements, because they would have been very discrete impeachment issues on very discrete topics, which I don't think would have opened the door to prior consistent statements, but even if you considered them consistent. And then looking back at the statements that were made to the other girls in the dorm, I wouldn't consider those prior consistent statements. I mean, those girls certainly were not consistent on what she had told them supposedly that night.
Fair to say that the rules of evidence on rehabilitating after an inconsistent statement applies to an inconsistent statement believed to be a fabrication at trial?
Correct. Not a fabrication prior to trial. So if a story had been fabricated shortly after the event and then told, it would not be prior, then you would not, my understanding is you would not be able to use prior consistent statements under that circumstance. The circumstance would be from the time the prior consistent statements are made, then the story changes for trial, is my understanding of the case law. I might not be articulating that so well, but.
Are you familiar with the various permutations of Chessie's statement of what happened that night?
Yes.
Are you aware of whether or not there were witnesses who could have articulated the various permutations of her statement that night?
Yes.
Are you aware of whether any of those witnesses were called at trial?
My recollection is one was.
At any time before trial, did Ms. Prout allege that Mr. Labrie forcibly raped her?
I'm sorry, say that again?
At any time prior to trial, in the statements that you are aware of from discovery, did Ms. Prout tell anybody, whether the girls in her dorm, Dr. Gettins, or anybody else, that she had been forcibly raped by Mr. Labrie?
Not that I recall from the discovery materials. Certainly not the girls in the dorm. That was not their statements. That was not Dr. Gettin's statement.
We'll talk about the computer charge. We can pass to another topic right now. Before trial, were you aware of the St. Paul's school handbook, which was included in discovery?
I had not seen that pretrial. It may very well have been in the discovery materials that I had in my possession, but as I said, I had not reviewed all of the discovery materials pretrial.
Have you now had an opportunity to review that?
Yes.
Judge, may I approach the court?
Yes.
I think I put all my copies of 26 in. I apologize. I'm just going to use this one for now. May I approach the witness, Judge?
Yes.
I'm showing you a document that's been marked for ID as number 26. That is the court's copy, so we'll need to return that. Can you take a look at that for a moment and let me know when you're prepared to discuss?
Okay.
Can you tell me what that is?
This is a portion of the St. Paul's student handbook that had been included in discovery materials.
Judge, I would ask that the ID be stricken and that be marked as a full exhibit. Number 26.
No objection.
Thank you.
Have you reviewed that portion of the handbook at this point?
Yes.
And did you review it in preparation to draft the motion for new trial?
Yes.
And for...
Well, the supplement. Well, I think it's accurate to say we had reviewed it before, but we were kind of still exploring the topic when we filed the original motion for new trial, and then ultimately had provided you, when you took over as counsel, a draft supplement to the motion for new trial, which had included this issue.
What issue?
What we had, so I believe the issue came to our attention through somebody else. I believe another student at St. Paul's had reached out to us and asked us if we had looked at the internet issue, and brought our attention to the fact that St. Paul's, that their understanding as a student at St. Paul campus was that there is an intranet email system. Actually, it may have been, let me strike that, let me be accurate. I think it might have been a parent of a former student of St. Paul's who originally brought it to our attention. So this person had brought to our attention that they believed students on St. Paul's campus had communicated through a intranet system, not internet system. We then, based upon that information, had gone to the handbook to look at the handbook and what the handbook said about technology and email usage. And then based upon that information, we had reached out to Attorney Delaney and interviewed someone from their IT department.
And does the handbook indicate that St. Paul's School does use an intranet system as opposed to an the wider internet for email purposes?
Right, so the handbook indicates that, and then we wanted to explore further about what that limit was, meaning, what is intranet versus internet. Obviously, a school like St. Paul's would have the students would have access to the internet. So there was a question in our mind about what that was and exactly how the emails travel on the system. So then we had arranged to interview through Attorney Delaney. He had made Scott Morin, an employee of the St. Paul School IT department, available to us to answer our specific questions about the root emails, student to student, student to student, St. Paul student to St. Paul student emails, how those emails travel on the system and what system they travel on.
Had this issue come up or been brought to your attention before trial, would it have been significant?
When the issue came to our attention and we explored the issue, it occurred to me that this is an issue that should have been explored pretrial and should have been the topic of some pretrial motions and discovery as far as an interpretation of that computer usage law as it applied to the specific emails of this case, knowing now that they likely travel on an intranet system, not an internet system.
Why would that be relevant?
Our reading of the computer usage statute was and is, and has not been determined by the Supreme Court to be otherwise, is that it's an internet, it's using a computer that is connected to other computers in the world through an internet, because it specifically says online service, bulletin boards, other things that necessarily connect my computer to random person's computer down the street through some kind of internet connection, an online connection. That was our interpretation of the statute, the plain reading of that statute. And so we read that statute, we read this policy that said St. Paul's emails are on an intranet system. We spoke with Mr. Morin, who indicated to us that yes, St. Paul's student email to St. Paul's student email would have been on our internal network, would not have gone outside our network, would not travel through the internet and come back onto campus. It would have been through our local server connecting student to student. And there's certainly, at best, a question about whether or not that would even qualify under the statute as online computer communication.
Is it fair to say that the difference between inter and intranet is not a simple thing to explore?
No, and I'm fairly ignorant when it comes to technology, which is one of the reasons why I had to go to Mr. Morin to try to understand the differences and what that means and how email would travel and whatnot.
Was there any indication in Attorney Carney or Zagangori's file that they had investigated this issue at all?
None.
Was there any research on this issue?
No.
Was there a copy of the statute in their file?
No. In fact, we had run, at some point we took all 3 of those thumb drives. We ran a search term for computer on those files, and 1 document appeared, and it was not related to the computer usage charge. No memos, no legal research, no notes, no mention of that statute at all in the file.
Had you been aware pre-trial that the St. Paul system used an intranet system while the computer charge requires an internet system, what steps would you have taken and what motions may you have filed?
I likely would have filed a pretrial motion, probably labeled it a motion to dismiss, saying if all these facts are true as taken, it wouldn't meet the definition of the statute, and litigated that issue with Your Honor. Obviously, Your Honor's ruling may have been contrary to my understanding, but I certainly would have litigated the issue pretrial.
Is litigation important for preservation of appellate record?
Yes. If you don't challenge something in trial or pretrial, you can't appeal it. The Supreme Court will only address issues that are preserved, properly preserved, pretrial, at trial. So if you don't raise an issue, especially a novel legal issue that's never been litigated before, if you don't raise that at trial, the Supreme Court won't hear you on it.
Did Attorney Carney ever discuss with you let me step back for a moment. You're aware that I think we're all aware at this point, that the computer charge has a lifetime registration requirement attached to it.
Correct.
Did Attorney Carney discuss with you, or was there any indication in the file that they had researched the Eighth Amendment and whether requirement to register as a sex offender, if not convicted of a felony sex assault, would be a violation of the Eighth Amendment cruel and unusual punishment provisions?
We could see, when we got their files, we could see all of their legal research that they had done and what date they had done it. And there was no research on this issue pre-verdict. The only research contained in Attorney Carney's file on this computer charge, the Eighth Amendment, or any issues relating to the computer charge were conducted by them after Mr. Labrie had been found guilty.
After Mr. Labrie had been found guilty?
Correct.
Your Honor, I'm going to object to that response. Attorney Rancourt can certainly testify to what she sees in the file that's been presented to her, but she can't testify to what may or may not have been done that's not part of the file that was presented to her.
That was the context in which I took her answer.
Thank you.
Are you aware of whether this was discussed with Owen?
Based upon conversations with Owen, and, well, backtrack. There's nothing in the file indicating any communication with him, meaning any correspondence to him, any memos documenting conversations with him about that topic. So nothing that I saw in writing, and based upon later communications with Owen, he'd indicated to me that they had not had that conversation.
Did you see documentation or memos of other significant issues that had been discussed with Owen?
There was very little written documentation about their correspondence with Owen. Like forwarding things to him, things of that nature. Sitting here today, I don't recall memorialization of many conversations they had had with Owen.
You reviewed the transcript of the opening statement?
Yes.
Did Attorney Carney reference the computer charge in his opening statement?
No.
Did he request a jury instruction? I'm sorry, a jury voir dire question about the computer charge?
No.
Were there any pretrial motions about the jury charge, about the computer charge?
No.
Did he move for a directed verdict on the computer charge?
I learned after the fact, no. So I did not know what their motion for directed verdict had been until I read the judge's order, Your Honor's order, on the motion to set aside the verdict. I think that was when I first learned that there had not been a motion for directed verdict on all the charges. That was the first I'd heard of it.
Had you discussed with Attorney Carney and Zagangori motions for directed verdict?
They asked me prior, like maybe the day prior to when they anticipated the state may rest, if they had to do it in writing. Because I guess in Massachusetts maybe it's typical that that's done in writing. So they asked me if they had to write a motion for directed verdict or if they could make it orally. And I had indicated to them that it's standard in New Hampshire to just make them orally, and that was fine. And that was the substance of the conversation. I think at some point Attorney Zagangori may have said something to me about we're going to focus our motion for directed verdict on that endangering charge that related to the prefect, to Owen being a prefect. But there was no discussion certainly of that they weren't going to move for directed verdict on all charges. They never told me that.
As a criminal defense attorney, do you routinely move for motion for directed verdict?
In every case, on every charge.
On every charge?
Every charge across the board, every case. I mean, sometimes you know you're not going to get a motion for directed verdict, and sometimes you have a real argument. I mean, sometimes I recall a sexual assault case we tried recently where we had a really good argument on a kidnapping. One of the charges was kidnapping. We thought we had a really good argument on that. We focused on that in our motion for directed verdict, but then we said, oh, and we also moved for directed verdict on all charges. And, you know, sometimes the argument's kind of weak, but you always make it because you're preserving your record for appeal by raising a motion for directed verdict after the state rests.
Do you waive the issue for appeal if you do not move for directed verdict?
Some issues you waive for appeal if you don't move.
At any time, did you have a conversation with Attorney Carney or Zagangori after file about the Eighth Amendment issues?
I don't recall having a conversation with Attorney Carney and Attorney Zagangori about the Eighth Amendment until they had sent me a draft of their proposed motion to set aside the verdict, and it was in that draft.
Were you present for the verdict?
Yes,
Did you speak with either of them immediately after the verdict?
I did.
Who did you speak with?
I spoke with Attorney Zagangori outside in the hallway,
How was he?
upset.
Did he say anything to you?
He did. He said, "We didn't think he could be convicted of the computer charge if he was acquitted of the aggravated felonious sexual assaults."
I'm sorry, he said he didn't believe that he could be convicted of the computer charge if he was found not guilty of the aggravated felonious sexual assault.
That was his statement to me. He said, I'm paraphrasing, I don't remember the exact quote, but he said to me, "We didn't think he could be convicted of the computer charge if he was acquitted of the aggravated," so you might just say aggravateds as an abbreviation for those charges.
Judge, it's noon. I have several pages to go. Does the court want to break or to continue?
This is a convenient stopping place, we can break for lunch.
It's convenient.
We will resume, it's 12:04, we'll resume at 1:05.
Thank you, Judge.
There's that exhibit that I had. I think that's the original.
All right, please. You may be seated. Court adjourned.
I should be. Yes.